Morning, Stephen. Thank you for being with us.
Thank you.
Thank you for being with us. We've got you for 10 minutes this morning, so I'll hand over to you.
I'm probably going to do something which I urge my clients never to do. I tell them that if they speak it through the whole time, they're wasting their opportunity to have an influence, and they might as well not turn up. But I'm concerned that you're hearing so much from so many people that it would be enormously hard not to be repetitive. You have my written submission, and particularly on what I think is a technical problem of the bill. But I've been reflecting because I've sat in your seat. I was 6 years on the Justice Selects Committee. I chaired it through some difficult bills when the chairman considered himself conflicted. I've heard lots of submissions, and I sort of remember what helped and what didn't help. But what I remember most was that when the door closed behind the media and there was no public, that around the table of that committee anyway, there was a genuine concern to do what's right for New Zealand. And we could have discussions that were quite frank, and that I don't ever remember any of the concessions that were being made. I don't remember the implicit deal being broken, that we were sorting out who really knows what's best on this. And I found my time on the Select Committee enormously satisfying. I was never in power. I felt I served the apprenticeship and never got the certificate. But almost every bill, you could see something that reflected an intelligent discussion, because I'd had the good fortune of being a lawyer for so long. And I'm looking at this now, and I heard Andrew Geddes say that we should leave it to the courts. I've just heard Liam say that the courts are not appropriate for that. I hear that's a thread. Essentially, if the bill or if Parliament doesn't deal with the principles, they are saying to the courts, you determine these very important elements of our Constitution. Mm-hmm. And I want to say, despite the fact that three of my former partners and good friends are on the Supreme Court, I think the judges are utterly unsuited to the role of determining constitutional issues. The magic of democracy is that the MPs are always looking forward, trying to work out what will happen with this, not what the rhetoric is. They know there's all sorts of bullshit rhetoric around slogans around bills, but how will it work? What will make it not work? And they take in information from wherever they can get it. You're spending hundreds of hours listening to people all over the country, and you're not filtering what they say pretty much at all. Courts are totally different. The whole legal training says I can make these big decisions because I work within a framework that excludes most of what people would say ought to be relevant. It doesn't get before the court just because it's true and relevant. It has to go through a set of formal hoops. The judges then apply to that logic, to a sort of logic that's predetermined. And ideally for a judge, the answer flops out without them having to put their own values into it at all. The answer flops out from the history, the facts, and the rules. It is totally different from the parliamentary role and from the role of a democracy. I want to give a couple of, I'll point to some examples. The thing that really worries me is that while I was in Parliament, the treaty issues for New Zealand and the way it's consuming us are a parliamentary inflicted disaster. We created it by reckless language, didn't know what it meant in 1975, didn't try and define it again. Judges did their best and then found what an opportunity it was, and now they're running with that ball. There are countries in the West seriously suffering. The leader of the British Conservative Party said yesterday that amongst the highest priorities is I'll just read it briefly, is the tolerance of things that will destroy us. My prime example is what's happening in the courts. We are having novel and expansive interpretations of law used in a way that was never the intention of Parliament. Parliamentary sovereignty is being eroded. Britain is in a chaos partly because they voted for Brexit and the courts then sabotaged it. For 3 years, they couldn't even get a deal. They voted strongly against mass immigration, and they've had 8 million people come in since then because the courts won't let them. export or do anything about it. It's not just the UK. Israel has had a paralysis with their Supreme Court, where the elite, the media, political, academic elite, and the courts, the lawyers are on one side and the elected representatives on the other. The October the 7th attacks broke that deadlock. The Romania judges have just declared the first half of an election invalid without any statutory authority. In the US, Ruth Bader Ginsburg referred to the US judges unilaterally made their abortion law. The US is the only country that's anything like us where abortion is a big issue, because we have the same religions, so does Canada. The US judges decided what the law would be. They never had the democratic debate, and it never had a democratic mandate. And it's been a cancer in US politics ever since. And we don't have that here because we reached our fuzzy compromise in the abortion law system, and the Abortion Law Reform Committee, which had judges and doctors, used to come before us. I guess they still come before you, saying to us, give us law that we can actually work with, because we were outside the law all the time. But the politicians knew it's a poison. Don't stir it up. And I say our Supreme Court is utterly unwise. They've neutered our extradition and deportation law to the point where, I don't know how, a few years ago, I know for a fact that 6 of the most wanted fugitives from China for corruption were in New Zealand. And the Chinese government thinks that our courts must be paid off because they're protecting these people from deportation or extradition. And that the courts aren't set up to take nuance into account. It may be a really material fact that it seems that possibly in Australia and certainly in Canada, China has taken to simply snatching the people it wants. When China decides to do that here, how can we stop it? And the judges will piously say, we will make up a rule that you cannot extradite someone to a country that has the death penalty. China's not going to stand for that. And so I'm saying politicians need to recognise that they have a very special role in melding together a whole lot of things, some of them which no one will even talk about when they make decisions. And decisions on the treaty and what it means and co-governance and whether people get ancestral political privileges or rights to decide how other people use their land, and whether Article 2 meant classical property rights or some kind of permanent influence from a neighbour who can claim a fraction of Maori blood. All of those things are intensely political. They will be intensely important to whether we're a healthy country. And we've got to remember that there are very few. Someone asked, I think it might have been Andrew Gears, can you think of any examples of countries where you share power in the way that's proposed? Well, I can. Iran, where a nominally elected government shares power with essentially a clerical group. And I think from my direct personal knowledge of lawyers, they think like clerics. That's collateral. If the outcome is bad, but you had the right motives and you applied the right rule, what actually happens isn't my fault. You know, I can give someone bail. It's not my fault if they went out and killed. It's not my fault if I apply the rules. That's a clerical mode of thinking. Who's a sinner and who's not? And there are many countries that are ruled by that kind of culture. I'm saying you're the lucky representatives, but also the unlucky representative. You represent ordinary people's instincts that someone's got to be the boss, and it must be the ultimate boss. And the countries where the families, the companies, the organisations where the nominal leader is not the leader and there's a tussle going on for control with others have spectacular failure, despite being rich in resources and people. And this country is heading for that. We are allowing the court to jerk around everyone else. We can look at this treaty area where it's obviously obvious, but very recently, the court has just let Fonterra and 7 other companies spend $9 million defending against a claim that falls squarely into the area of the Climate Change Commission and the ETS. And Parliament could have said to the court, get back in your box. You can't invent law like that, which they did in the Smith and Fonterra case. Instead, it's done nothing. It's allowing that to go further. There'll be another 9 million spent before it's finally tossed out. And it'll take 3 or 4 years. And in the meantime, people are saying, do I invest or will the courts make something up that snatches my property? We don't know. We are in a limbo where our court is asserting itself and Parliament is not stepping back. So to those who say Parliament should not be looking at the treaty principles, my message is it absolutely should be, and it should be doing it very overtly, and it shouldn't be apologising for it.
Thank you, Stephen. That's the time this morning. We don't have time for questions, but just want to acknowledge your submission and thank you for that insightful submission. We do appreciate it.